Okay, welcome back, everyone. I hope you had a good lunch. So we are about to start the third and final domestic developments panel of this roundtable. The next panel will be talking about international developments that have happened. Once again, I want to remind everyone, try to keep your remarks succinct so that we can let everyone have an opportunity to get their points out. If for some reason during this panel you don't get to say everything you want to say, or someone says something that you feel needs to be responded to, please do remember there is an open mic at the end of the afternoon. There is a sign-up sheet. We welcome even audience members who may not have participated on one of the panels to speak and offer their views at that point. So with that, we're going to do the quick round of introductions, your name, your affiliation, a very brief description of why you're here, why you care about this issue. And we'll start with Dr. Burgess.
Thank you. Is that on now? Yes. Okay, thank you. Okay, my name is Richard James Burgess. I'm the president and CEO of the American Association of Independent Music. From our members' perspective, things are not that much different than they were in 2017 or before. Notice and takedown hasn't helped much with stay down. We still have repeat infringes, and we still have to send amazing amounts of notices to get anything done. We're cautiously optimistic that the EU copyright directive might improve things, and it does establish that a large regulatory body realizes that the spirit of the law is not being adhered to.
Good afternoon. I'm Alex Fierst. I am head of legal at Medium. It's a publishing platform. We have about more than 10,000 posts a day go up on Medium, written by various folks, including more than 15,000 writers who get paid for their work. I also run a team of content moderators at Medium, which is called Trust and Safety sometimes in the business. And I'm here, I think, most of all to help embody and talk about the moderator's dilemma and the way that red flag knowledge sort of hangs over the head of my team that's trying pretty hard to make a thoughtful and civil space on the internet for people to write and engage, while taking down things like violent content and terrorist content and all sorts of other things, and trying to be mindful of the rights of creators who come to our platform to write.
Okay, Professor Heartland.
Hi, I'm Devlin Heartland. I'm at George Mason University. I'm here to talk about how I think Section 512 is not intended to be solely a notice and takedown regime. Congress intended to preserve incentives for service providers and copyright owners to cooperate to detect and deal with copyright infringements. And so the idea was that service providers would also play a role in preventing infringement, and they would do some of the work in finding and removing infringing content without input from copyright owners. And the main way that Congress intended for this to happen was with the red flag knowledge standards. That is, service providers would lose their safe harbors if they're aware of facts or circumstances from which infringing activity is apparent and fail to act. But the courts have read the red flag knowledge standards so narrowly that only a fire engine that's actually on fire will suffice. And one need look no further than the fact that Google can index the Pirate Bay with no concern for losing its safe harbor to see how things have gotten out of hand. 512, on the other hand, was supposed to be commonsensical, and it wasn't meant to only turn on knowledge of specific infringements. Properly understood, red flag knowledge is general knowledge. It is a subjective knowledge of facts or circumstances that a reasonable person would understand to be apparently infringing. And the burden of investigating a red flag should fall squarely on the service provider. Thank you.
Okay, thank you. Ms. Gilles.
Thank you. I'm Kathy Gilles. I am a technology lawyer, and I've given some oral testimony under my own auspices at the last hearing, and I filed comments on behalf of the Copia Institute when the comments were solicited. There's 2 rounds of that, and I'm here today under the auspices of the Copia Institute as well. The first point I want to make is that not to let the sky is falling rhetoric skew the recommendations that you may feel driven to make. The sky is not in fact falling, it is in fact rising. The pie is growing, there is more revenue, there are more works, and all of this upward trend is due to the internet. So we have to be really careful not to kill this golden goose and ruin this benefit that we have, and make sure that we have in place what's allowed this pie to grow. The Copy Institute just today, in partnership with CCIA, has put forth a report aggregating a lot of the data, providing the evidentiary record for that statement. It's available at skyisrising.com.
Okay.
But the second point, I'm sorry, don't want to cut off any interest in that report whatsoever. But the second point I want to make turns the corner a little bit, and to say that even though things are good, there's still cause for alarm. And I'm thinking of cause for alarm about the pressures that are falling on platforms and ultimately on individual creators, expressors, internet users. We're discussing these cases. I imagine you'll ask us the questions again about BMG versus Cox and Mavericks. And in all of these cases, there's many differences between them and many things that could be said. But the chief cause of alarm is something that we flagged in our previous testimony and also in the comments that we made, which is what the effect is of unadjudicated claims of infringement. This is the only area of law where somebody can just say, I think I've been wronged, and all of a sudden everybody needs to react without any court ever adjudicating whether a wrong has actually happened. This is
Okay.
something we need to pull back on.
Let's put a pin in that, and we'll definitely get back to it. Professor Goldman.
Hi, I'm Eric Goldman. I'm from Santa Clara University School of Law. I'm going to answer Mr. Amer's question about Section 512F. I pulled all of the cases that reference Section 512F since January 1, 2017. There have been about 25 such cases. Less than half of them actually substantively analyzed the doctrine. Other times it was just a stray reference. I did not find in my research any cases where a plaintiff under 512F has actually won in court during the time period. In fact, that's not inconsistent with past jurisprudence. I am aware of only 2 times in which a 512F plaintiff has ever won in court in the last 21 years.
Mr. Gratz.
Thank you. I'm Joe Gratz. I'm a partner at Dury Tongri in San Francisco. I litigate cases at the intersection of technology and copyright law. There haven't been that many cases since the last set of roundtables. And I think what that reflects is that the system is working, that the players have, at least on the whole and in the main, reached a rough modus vivendi that is leading to at least somewhat less large-scale litigation on 512 than we've seen in the past in, for example, a Giganews type case or a Viacom YouTube type case. What case law there has been since 2017 has shown the importance of the flexibility of the current law and the ability of courts to take into account the particular circumstances of a case, whether that's in the context of what it means to be expeditious, in the context of what it means under the circumstances to make a knowing misrepresentation under 512F, or in the context of the repeat infringer standard, taking into account the differing circumstances in, for example, Cox and Motherless.
Okay, Mr. Pollan.
Hello, my name is Jared Polin from FroKnowsPhoto.com. I'm a content creator. I'm a photographer. As of 9 years ago, I started a YouTube channel, and I create free, fun, and informative content that helps photographers and creatives around the world figure out how to take better pictures, but also make money on the internet. I build everything off of free, so I give away all of this content in the hopes that people will support me by purchasing some of the things that I do end up selling. And so I'm here to lend my hand as a creator, somebody who makes a living doing this, has 2 full-time employees off of a YouTube channel that I pay benefits for and 401k. So as a small business, I'm here to help as the guy that's creating content to be a voice for, well, I don't know if reason counts, but for something.
Okay, Mrs. Ray.
I'm Tampa Ray with NTCA, the Rural Broadband Association. I'm the NTCA.
Go to green.
Make sure your light is green.
Hi, okay. Sorry, it was on the 4. Thank you. I'm Tampa Ray with NTCA, the Rural Broadband Association. Among NTCA's members are approximately 850 rural small broadband providers who cover approximately 33% of the landmass in the United States. As the sole broadband provider in many of their communities, they're having a hard time reconciling courses, the Cox Grande versus Peckingham cases. In many cases, they have implemented and followed through on repeat infringer policies. Despite these efforts, they continue to see, in most cases, the same number, if not more, of DMCA notices coming through. As a result, they're looking for guidance, looking for perhaps refinement of the repeat infringer policy so that the purpose of Section 512 can be carried out and they can be aware of their responsibilities. Thank you.
Okay, Mr. Schwartz.
I'm Bob Schwartz, law firm Constantine Cannon. We're here as outside counsel to Consumer Technology Association. In my career for CTA, we focused on so-called gray areas of the law, and we've learned that the daily outcomes are really based on toleration, accommodation, and implied license. For example, just yesterday in my side career as a performing jazz musician, and I stress I'm not a full-time pro like Mr. Hatfield you heard from this morning, and I fully know and respect the difference. I fairly routinely quoted 4 bars of the in-copyright tune Manhattan while heading for the end of the public domain tune Love Will Find a Way. This is quite the routine in jazz solos and even jazz arrangements. So the notion of if you curate for one thing, you need to curate whatever is uploaded or whatever appears just cannot possibly work in this sort of context, ignoring fair use, ignoring accommodation, ignoring all sorts of other considerations. And if it were tried, it would probably hurt the people that do need some help, and that is really intended for.
Okay, thank you. Mr. Tonko.
Thank you, and thanks for convening this roundtable and for undertaking the study that you guys are in the midst of. My name is Christian Troncoso. I'm here on behalf of BSA, the Software Alliance. We represent a coalition of software companies that provide an array of enterprise cloud services. We bring somewhat of a unique perspective to these conversations because in addition to representing our members on policy issues, we also operate a robust online enforcement program on their behalf because their software is also subject to large volumes of piracy. So at the same time, our companies in operating those enterprise cloud services that I mentioned earlier are very reliant on the safe harbors themselves. So we have a bit of a dual perspective on these issues. And from our perch, we see the DMCA framework largely operating as intended. Certainly there are frustrations when you look at the framework from one perspective. If we talk only to our content protection folks, they have many of the same concerns that others have mentioned today. But when we talk to our companies in terms of their operation of enterprise cloud services, it's sort of, we see the frustrations from that side. And sort of it's one of those classic situations where there's a little bit of frustration on both sides, tends to show that the compromise was fair in the end. We think that the DMCA, the other sort of important stakeholder in these conversations, are end users who are also subject to the outcomes here. So just, I'll sort of leave it at that, and we can talk about the case law.
Okay, thank you. Ms. Tamarello.
Hi, I'm Kate Tamarello, policy manager at Engine. We're a nonprofit based in DC and San Francisco that advocates on behalf of startups for pro-innovation policies. The American startup ecosystem is thriving in part because of our balanced copyright laws, including the DMCA, which have allowed innovators to create new platforms for users to share ideas and content. Startups support Section 512 safe harbors because they reduce the risk that a company could face ruinous litigation over alleged infringement occurring on its website. While issues do remain concerning bad actors sending false notices to startups, we fully support the DMCA framework and will continue to engage with the Copyright Office to protect Section 512 and Internet safe harbors. Thank you for the opportunity to join the panel.
Thank you. Mr. Wang?
Yes, my name is Wang. I'm a writer and a freelancer for 20 years. It's an honor to be here today to learn from you and to share my stories and opinions on this important issue. As you all know, the EU has just passed its copyright directives. I have been closely following the development, and I have been advocating the similar US version since 2001, and spent almost $20,000 of my own money to advocate the same thing. So I think I have a little bit different perspective to present to you guys, but I think it's necessary and important. Thank you.
Thank you. Ms. Wolf?
Yeah, good afternoon. Thank you for convening the roundtable. I'm here, well, I'm a partner at Cowan Debates, Abrams Shepherds, but today I'm here on behalf of a trade association I've represented for many years, now called the Digital Media Licensing Association. And that's the association of aggregators that help content owners in the visual arts, whether it's still or motion, monetize their content by licensing. We were here 3 years ago, and I would say I don't think there's been much improvement in the balance of the DMCA when it comes down to trying to encourage licensing and decrease piracy. The internet would be empty without visual content, yet the burdens of the notice and takedown exist, and the way the courts have been interpreting things such as red flag knowledge, there's really the lack of incentives to cooperate and work collaboratively with the content licensing industry, particularly in the visual arts. There's much fingerprinting technology available, yet there's little incentive ever to do any type of filtering. And there's also seems to be little incentive to develop licensing systems. You can see from Mavericks that curation makes a much better website, but there doesn't seem to be any encouragement to develop the licensing models to make that happen.
Okay, thank you. So since this is the last domestic panel, we're going to shake things up a little bit, and we're going to start with a topic near and dear to Professor Goldman's heart, which is 512F. And I actually want to begin by asking Mr. Graz a question. In the San Francisco Roundtable, you mentioned that 512F needed to have more teeth when dealing with abusive notice senders, and you suggested statutory damages. What have you thought of the recent 512F decisions in the wake of Lens? And do you still think 512F needs to be changed, and if so, how?
I do. Thank you. I do. I think that 512F, as the review that Professor Goldman has recently published on his blog that I'm sure he'll be talking about, as well as sort of the experience in the world, is that 512F is not a sufficient deterrent for many kinds of abusive notices and counter notifications. There haven't been many litigated cases on this, purely because I think what is at stake in any given situation is not always enough to support litigation. But I think that we may be seeing a greater number of those cases coming in the future, even under the current standard, not because of anything that comes out of Lens, which I think sort of restated what I think the way that most people had already been operating, but because of increasing and new ways that as the internet becomes and as internet intermediaries become a more and more important part of more and more economic activity, especially on marketplaces like Etsy and other online marketplaces, the competitive incentives to send bogus counter notifications and counter notifications will become so large that there will all of a sudden be an economic incentive or situations that support economic incentives for litigation.
Sorry. So sort of on that point, on the last panel, Etsy alluded to an increasing amount of fraud in both notices and counter notices. And there's been various discussion that sometimes it's used to harass and for non-legitimate purposes. And in your opening statement, Professor Goldman, you mentioned that there have been several cases under 512F since we last sort of heard from people in this study, but that no plaintiffs have won. Do you think that's a good thing, a bad thing? Is it a problem with 512F? Is it a problem with the courts? What's going on?
Yeah, I think that the data suggests that either there aren't abuses that are worth litigating, or the law is miscalibrated to protect those abuses. And I think we have plenty of evidence to suggest the latter, that there really is no meaningful incentive to do homework before sending a notice, and that creates lots of opportunities for bogus notices to be sent. And in addition, there's often a lot of background context that's taking place. One of the 512S cases, for example, involves a dispute over a screenplay that then morphed over into one of the marketplace cases that Mr. Graz mentioned. And the service provider isn't in a good position to resolve that. And the 512F claim is really just a chance to tweak the rival over the screenplay, not actually to resolve the merits of the underlying copyright dispute. It's just an ancillary way of the parties fighting with each other.
And just a reminder, if other people want to chime up, feel free to turn your card up and I'll call on you. Otherwise, I'm going to keep singling people out.
I do have a follow-up question to that. Professor Goldman, you mentioned abusive notices. Now, I know relatively few counter notices are filed. There are obviously abusive counter notices too. My recollection, and I want to be corrected on this if I'm wrong, is that the recent 512F cases, and I'm thinking specifically, I think it's Johnson v. New Destiny Community Church, are applying the same standard to counter, whether it's counter notices or notices. Is that right?
That's my understanding, yes. Right, but to your point about counter notices as a counterbalance against the abusive notices, there's so many things that have to go right for a counter notice to even be filed, let alone be effective. First, the service provider even has to acknowledge that they want to honor counter notices. The user has to understand those rights. The user has to feel confident that they're willing to submit it, and they have to be prepared for the consequences of filing the counter notification. So there's a whole bunch of things that are stacked against filing counter notices. And so to think that the current system encourages counter notices as an appropriate counterweight against abusive notices, I just don't think that the system is designed that way.
I guess I have a question to that, because if you're focused on a user being confident enough and educated enough to even file a proper counter notice, sort of making it easier to be liable for filing an improper counter notice doesn't seem to encourage the filing of counter notices. Or would you decouple the two standards?
I'm sorry, could you try that question again?
Yeah, so if it's the same standard under F1 and F2, and under F2 you're not seeing counter notices because users may not realize or may be a little intimidated to file a counter notice, will that make it harder for users to file counter notices if you loosen up the standard for liability under F1 or F2, since they are the same standard?
To the extent that counter notices are a non-factor today, I don't think that making it harder to file counter notices will have a material impact on the overall ecosystem. So to me, that doesn't really, that's like the tail wagging the dog. Focusing on the abuses of the notices would be the place to start, and I think the material impact on counter notices would be relatively de minimis.
Okay, Mr. Pollan.
Thanks. So on YouTube, I get hit on occasion with some claims. Saying that I've uploaded something that is copywritten, and many times I have permission to use it or it's fair use. Then other times I can file a counterclaim. It's super simple to do on YouTube. It walks you through. It asks, are you this person? Are you sure you want to do this? Are you, and I do. So I go against it, and I generally win because we try to stick to general good practices when we're posting content, that it's my content, or if we're in fair use acknowledging something, we're talking directly about what that is, and then file the counter notice, and then it's taken care of in a matter of days. So YouTube does a very good job of that for us.
Okay, Ms. Wolf.
Yes, I actually think that in particular with visual content that's online, that filing the counter notice really puts the content owner in a disadvantage, particularly if the counter notice is in bad faith, because you really can't afford to go to court within 10 days and file a claim because the damages aren't high enough and there isn't any alternative to federal court. And typically, if you don't have a copyright registration before that, you'd have to spend at least minimum $800 and then find a lawyer. So I think that if counter notices are done improperly, there's actually more harm to the copyright holder.
Mr. Wong?
Yes, regarding this issue, most answers could be found, the questions you guys raised. If you keep closely following the EU, the Europe, how they develop this copyright directive, you may know most answer has clearly been answered. Memes, upload filters, fair use, legal uncertainty. I don't want to talk more about that. You guys could easily find the answers from online. One thing, when we talk about this infringed content, you mentioned YouTube, but that's only part of it. Most, companies like Google, they earn money not this way. See, from this hundreds of my pieces were taken advantage of this way. It's 2002. Some guys just post my content, my writings there, and Google just ran it aside. 2002, 2003, 2008, 2012, 2013, 2016, 17, 18, 19, till last month. They keep doing that. For this piece only, they run 6 ads around. See, it's like parasites around my content. They keep, it stinks bad. For this piece, you think it's longer than this. I just cut it for easy to review. It's got, for this piece alone, I'm writing mainly in Chinese, but occasionally in English. It got millions of clicks online. It's a hot topic today. Only for this size, this online advertising companies could earn tens of thousands of dollars, but I get nothing. That's the point. When you talk about YouTube, it's the content they hosted on their server. Oh, they have some responsibility. But how about these things? I called the Google's engineers. Can you fix it? They said we can easily can. Easily they can fix it. But why don't you do it? He smiled. Because they earn money this way. It's so simple. They said, we can handle the content ID. We can do it even on video, letting aside the test. It's very easy for them. And I presented with 2001 or 2011, many years ago, to them. I asked them, Google's production teams, is this a good idea to fix the problem? They all agree. The engineers agree. But why you don't do that? They said, well, because it costs them money. But it's very easy to fix. That's one point I want to mention.
Can I just ask, just to clarify, so where are those works being posted?
It's, I use Chinese to write. Around the world, some content pasted, the Chinese community in United States, some in Canada, Malaysia, Taiwan, Japanese, all around.
So just different people's blogs or websites or
different websites. It's just out of control. Okay. Just out of control. I don't blame these small forums. There's just a couple hundred people. But for Google, this big company, they can use this. They told us, they give how much money to the content creators through YouTube Content ID. It's a bit easier. And I called them, why you don't do that?
And so are you sending a takedown notice in that case? Are you sending a takedown notice?
Yes, that's another issue I want to mention. I closely follow the issue. The Europe Parliament members, I talked to them. They told me one thing. Why should we do something to prevent you doing something wrong? Why we have to notice you? You need to ask permission first. Without permission, you just don't do this business. You just don't use my stuff. Why I have to find my stuff being infringed? Why I have to always do something? I write, hours a day. I don't have time. See, it's more than 100 pieces and more than 100 websites. I asked a lawyer, how much you charge for a letter? $1,000 US dollar. How much money could I have? I already paid $20,000 my own money to do this. I cannot keep like this anymore. Thank you.
Thank you. Mr. Graz.
Returning briefly to the issue of why we see a relatively low rate of counter notifications and whether that's consistent or inconsistent with the idea that 512F needs to be strengthened. I think that they are unrelated in that I don't think that anyone who ought to be sending a counter notification is failing to do so because of a concern about 512F. I think that lots of people who ought to be sending counter notifications are doing so because of a concern that it will potentially lead to litigation. And I mean that especially in situations where the person is very certain that they would prevail in any litigation. That is, sending a counter notification is sort of waking a sleeping dragon, even if you're really, really sure that the dragon is wrong, because because litigation, as Ms. Wolf rightly says, in this area can be so expensive.
Okay, Ms. Gilles?
Thank you. I'm half backing up to the 512F and half perhaps anticipating that we may speak more on the Cox case later and the 512I issues. The first thing I wanted to flag is comments that we made at the last hearing and another comments about the First Amendment problems with how important it is to protect the right to anonymous speech, and that 512G forces a user to self-unmask, and that is a deterrent to people unmasking themselves. Especially when they end up in cross-horns where they've made anonymous speech against a more powerful person, and that powerful person wants to shut them up. Then the notice and takedown becomes a weapon that that person can use and abuse, and if 512F has no teeth, it's very easy for them to abuse it. And if 512G is the only remedy, that's kind of game over for that speaker. So that's an important point to flag. The second point is 512F, we're largely dealing with, I agree with what Professor Goldman and Mr. Graz have said about the lack of adequate teeth. But I think also, in leaping ahead a little bit to the Cox case, is for the 512I safe harbor, we don't even have the same notice requirements built into the notices. So never mind that 512C type notices are not being filtered out for abuse very well because we don't have the deterrents built in. We have even fewer deterrents for the types of notices that end up going to the 512A platforms. And then if all of a sudden that's running into their termination policies where they have to tally up each particular some form of complaint that they received, when there's even fewer deterrents to make sure that those complaints are valid, that's a more serious concern, especially when we look into not only that are these notices being used to remove specific forms of expression, but they are increasingly getting gamed to cause a speaker to be removed, where people are sending notices to platforms with the understanding that they're going to use up the number of strikes that they believe that that whoever spoke would have. I think there's a lot of myth that there may be 3 strikes and then you're out. Obviously, that's not necessarily the law, but the more important it is for a platform, especially perhaps the larger platforms, to have some sort of specific rubric where there's a tally, a quota of how many complaints they can receive before all of a sudden they have to take action to terminate a speaker on their site, the easier it is for people to game that. And they're gaming it not just to hit a specific form of a specific item of expression, but they're trying to get at the whole speaker to make sure that they get turned off from that platform entirely. And that's something we need to be really cognizant of not allowing to be gamed, or else it will totally silence speakers entirely.
I mean, interesting the point you just made, and I haven't actually heard about this because we heard a lot before about YouTube competitors who issue a largely fraudulent takedowns. Their competitors' video will be taken down by the time it gets put back up. They've sort of lost their marketable window. I haven't heard this before, where you're saying that there are people who are targeting their competitors by trying to get them, 3 strikes and they're out, or whatever the strikes is. Where did you see this? Have there been studies on this?
I don't know if there's studies. I was rummaging around trying to find some of the anecdotes that I've seen. I can't say that it's not competitors trying to do that. I imagine if we have this roadmap, that will happen if it hasn't happened already. Where I've seen it is social media, where people are saying things that people don't like. People may be the type of speaker that other people don't like. And I've seen righteous tweets about, I didn't like this, so I sent a takedown notice to Twitter, not just because I wanted that to come down, but I wanted to use up his quota so that that's a strike against him so he can't keep doing it. I'm remembering that one in vague and concrete terms, but I don't think it's the only example I've seen. I've seen that kind of logic percolate up in discussions where people think that's how it works, and I'm really concerned about that becoming how it works. So that's my point to make.
Okay, thank you. Professor Heartland.
So I just want to say, of course, bogus takedowns are a problem, absolutely. But I feel like the hyper focus on this is missing the forest for the trees. So I'm looking at Google's transparency thing. It's very helpful. So they've been asked to take down over 4 billion URLs, right? And as far as I know, the vast majority of those requests are legitimate. So that's the forest, and we're focusing on a couple trees when we're talking about bogus takedown notices. And in fact, it seems to me that if the standard under 512F is bad faith, that I'll bring it back to 512F by talking about the Linz case. Hopefully you'll let me do that because cert was denied after your deadline. So I just I just want to say that I think the court in Linz got it totally wrong, and here's why in one sentence. So the 512F standard is that you have to have a knowingly materially misrepresentation, right? So that is, you have created bad faith in your mind. The thing about good faith, what the court was trying to bring it in under, is the fact that you haven't formed a good faith opinion that it's bad material. So, but there's a difference between having actually formed bad faith versus not having formed good faith, and the court conflated those two things.
Okay, Mr. Fierst.
Yeah, I just had a couple of sort of concrete experiences I thought I'd share from this. One of them is that, so for my team, when we get a DMCA notice, if it's defective or if it seems like it's, for whatever reasons, it doesn't make sense, we'll engage with the person who sends it to try to help them and talk about the statute and get the information that seems necessary to make it compliant. I think I'll leave the nuances of 512F to others, and I'll just sort of say that there's a large number, a substantial number, that suggests to me that at least for some percentage of folks, the gravity of what they're doing, which is sending a notice that extrajudicially causes something to be taken down, is not apparent in the way that they interact with us, because they will say things like, I'm not going to do your job for you, and send an incomplete notice without the URL of the infringing material, which is an extreme, but and relatively unusual. But I think the tenor of all of this is that I think for us, we want to try to help folks give us information that will cause us to take down anything that's going to be inadvertently on the site. But the relative sloppiness, or sometimes the lack of complete information that we get, is just a frustration that we try to engage with people on, try to get all that information. But I think...
Can I ask you to refine a question? So it sounds like you feel that the provision of the law giving you some time to expeditiously remove material is forgiving enough to allow you to have this back and forth with sort of like a potentially wonky takedown, where you can figure out if it's really a copyright claim or if it's really a takedown that you're going to honor before, as opposed to an obligation to like act immediately.
So I'm not sure. I mean, I think I would say, the way that you're framing it, that is risk that that we would have to take on, because the definition of expeditiously is something that might be defined later in whatever forum. So I think in the instances where we take on additional risk in order to help folks, I think that's what we're doing. Whether that's proper or fair, I sort of leave to others, but I think you're saying that we have the time to do it is really the fact that we've made a determination that we're going to take on the risk that we might be deemed to have taken too long.
The risk that these actions you're talking about fall within, still qualify as expeditious removal.
I'd say it's because we care. I don't know if we do it comfortably, but it's something that we're doing.
Okay. I'm going to let Dr. Burgess speak as well, but after that I'm going to switch to a slightly different portion of 512F and talk about automated notices versus forms versus other ways of doing it, and whether there's been any change. So, Dr. Burgess?
Well, I want to express concern about the emphasis on hearsay and rumor that I'm hearing coming from Ms. Gilles, and also address something that she brought up earlier. I mean, we need to go back to first principles here. I represent more than 600 independent labels. The majority of those labels have given up on the notice and takedown system. It's not working for them. They can't afford it. And these are not sole proprietors. They're reasonably successful independent labels for the most case, but they've just given up. And
Do you disagree with Mr. Graz that the last couple of years have shown a modus vivendi of how we can get on from the perspective of the individual labels?
I'm sorry, I couldn't catch it.
Like Mr. Graz said, starting out, the last couple of years, there's been relatively few big cases, and that kind of shows everyone has figured out how to work within the system voluntarily.
No, it's that people have given up on our side, and they've just. That's why I say, we sort of have some hope that maybe the EU copyright directive might actually shift the conversation. But then Ms. Gilles said something in her opening speech, which is that the internet is the golden goose, and that the industry is rising, and actually content is the golden goose, not the internet. And it's worth remembering that the music industry, I'll just speak about the music industry, for example, is now on a retail basis somewhere around the 8 billion mark. In 1999, it was on adjusted dollars at about 21 billion. It was 14 billion at the time. That's about 21 billion today. So the music industry is still only slightly above a third of what it was 20 years ago before it was disrupted by pirates. And we still have that situation, basically. So it's fine to focus on these counter notices and everything, but when I'm hearing immense amounts of rumor and hearsay and, voices that are obviously funded by these platforms that benefit from the piracy of our content, then I just wanted to go back to first principles. We own this stuff. We should not have to be responsible for other people's wrong use of it.
Okay. Mr. Pollan, I'm going to let you respond, but then we are switching topics.
I just, as a content creator who gives away a lot of my stuff, the one thing I don't want to see happen is the gatekeepers shutting the gate again that we've been able to open up through the platforms that we have access to today that gives me the ability to make money off of free and then selling. We talk a lot about musicians not making as much money as they used to. Well, a lot of them, some of them don't deserve it. They're not working hard enough, some of them. They're not doing what they need to do. They're stuck in the old ways. And so you got to use what's here today to grow. I work with a lot of musicians, and a lot of the musicians I photograph, I have a larger online presence than they do, and I built it off of free. So what I don't want to see is a gatekeeper come and shut the gates again on us from being able to do what we're doing, and that's, content is a major thing, so that's it. That's what I got.
Okay, and so sort of switching gears a little bit, there was a lot of discussion in the prior roundtables, and I think no consensus about what is the optimal way to have a notice and takedown system. On the one hand, we hear people like Mr. Fierce complaining that some of the notices they get are sloppy or are not complete. We heard some discussion that sometimes that's maybe more smaller content creators than larger ones. We heard other ISPs complaining about the volume of automated notices they were getting from some of the larger ISPs. And then we had yet more individual content creators complaining about, for example, Google creating a form rather than allowing notices to come in via email. And I think Ms. Wolf, Dima mentioned in their initial comments that they had some concerns after Lens as to whether that was going to shut the door on automated notices or whether it was going to somehow bring the system grinding to a halt. And so I'd like to hear people's experience. Has anything changed? Is there more consensus about what the best way to handle these notices are? Are there preferences? Is it hopelessly lost? Mrs. Ray.
Thank you. I'd just like to speak to the issue of the volume of notices and where they're coming from and to the notion of whether streamlining would help. Many of our members have commented that the volumes in some cases come repeatedly from different email addresses, even though they may have and do have a single DMCA registered email address, and that's where the notices are supposed to come to. They'll come to there, they'll come to multiple email addresses, and they may or may not be identical DMCA notices. So they're having to struggle to compare the notices, first of all, to make sure they are in fact duplicates. If they're not, of course, then they act on them. The other difficulty that they're running into is many times they will get notices for the same subscriber for the same song from the agency representing the copyright owner, resulting in multiple notices for the same song for the same subscriber. So to the extent that those could somehow be minimized to more effectively identify where the concerns are, where the copyright infringement may be occurring, because from an ISP standpoint, looking at the court cases that have come around, and similar to what we're talking about earlier in the 512F, is what about these instances where you get the same notice at multiple email addresses, but they don't count as just one notice. So to the ISP and to the court and to somebody challenging the ISP in court, they're going to say, hey, you got hundreds of notices for this single subscriber in one day, and you only acted on one. While they could probably, perhaps, hopefully defend that, it's going to take a whole lot of record keeping on the part of the ISP and a whole lot of attorney's fees.
Okay, Ms. Wolf?
So I would say, that I'm not sure Lens has changed the landscape for members of DMLA. They may use image recognition technology to find matches, but there's always been a level of human involvement to review. I mean, it's very complicated. It's not easy to check, because you have to check whether a work was licensed or not. And I think there always was a look at whether something could legitimately be a fair use or not. I mean, I have recommended that members actually assert that in their letters to say they have considered fair use. I think the real problem is just the entire system itself, and I agree with Dr. Burgess that I think many just have given up on doing it because there's only so many hours in a day, and the members of the organization represent content owners that are in the business of trying to make money, and they could spend all day searching the internet and trying to determine who has licensed what and who hasn't. But I think they feel very frustrated at the process, not just 512, but the expense of litigation, and of course have been very much in favor of having a copyright small claims for the infringement areas.
If I could jump in here with a follow-up to that, because the second person in a very different area of content that's mentioned this frustration and maybe drop out from the notice sending system. In 2016, Google's representative in San Francisco, Fred von Lohman, mentioned that the high volume of notices shouldn't be taken as a negative, but actually a sign the system's working. Since then, which is right about the time that Google's notice reception peaked at about 20 million I think it was per week or per month, 20 million per takedown request per week. Now it's down closer to, I think, about 15 million. And I was going to try to put on the spot Mr. Graz, who one of his hats obviously is as a Google lawyer. Could you shed any light on what you make of that?
Thank you. I want to clarify that I'm here on my own behalf, though, as you say, Mr. Greenberg, I have previously represented Google in litigation. I think that with respect to the number of takedowns sent to Google, or the number of takedowns that are reported in Google's transparency report, that number verges on meaningless because the takedowns that are the vast bulk of those takedowns are for sites that or items that were never indexed by Google in the first place, or that never appeared in Google search results. That is, people are using the Google search result takedown form as a general, I haven't seen this anywhere, but there is infringing material somewhere on the internet. And so to that extent, I don't think that the number reported there as a bellwether of anything in particular is likely to be particularly meaningful, particularly at the difference between double-digit millions that are probably mostly set by a relatively small number of automated submitters.
Okay, so we're going to go with one of our quiet folks, Mr. Troncoso.
I just wanted to
briefly return to your original question about sort of what would be the ideal structure for a takedown framework in order to create the most sort of efficient system. I think part of the difficulty in answering that type of question is the sheer diversity of stakeholders that have to operate under the statute. And that's true both from the service provider side. You have search engines, you have social media companies, then you also have enterprise cloud companies who are 512c companies who provide services to 512c companies that sit on their infrastructure. So coming up with a single system that is going to work for all of those stakeholders is very difficult to imagine. At the same time, on the content side, right, you have a lot of different types of content with industries that have different licensing processes and how they like to interact with services. So coming up with one ideal framework probably isn't going to work, which is why we think the DMCA has done a fairly good job of allowing for bespoke sort of systems to arise. So you have, Mr. Gratz mentioned earlier, Google is doing things that are not necessarily required by the statute, like de-indexing content before it has even appeared on their service. The DMCA provides the incentives for those types of behaviors because Google has the incentive to make sure that they are limiting the sort of resources that they need to throw at a problem by dealing with it sort of on the front end before these sort of links have populated on the service. So again, just making the point that sort of there's a lot of actors and sort of balancing the interests of all of them is not easy, but we think all things considered, the DMCA has done a pretty good job.
Okay, I see we have one more person who hasn't spoken yet who wants to speak, so Mr. Schwartz.
Well, Google is also, of course, a member of CTA. And CTA's view has been that with all of these variables and difficulties, the burden has to be, for initiation, has to be on the rights holder. Now, in a previous round, CTA made a public comment discussing the progress that has been made, not only in automated filtering, based on agreements and material provided by content owners and Google's technology, but also in automated takedown notices and how all of that was working. And in discussing progress in this area, one of the organizations of content holders jumped in and said, well, it's glad that CTA agrees with us that the burden, they're doing so well at this, the burden really needs to be on the host and the platform, not on the rights holder. No. The top of the funnel, knowing what's there, knowing what the complexities are, and it's tough for everybody, has to originate with the rights holder. I'm sure I'm not going to persuade everybody on this panel of that, but I'm here for CTA, and that certainly has been CTA's position consistently.
Okay, I think the order of requests went Professor Goldman, Mr. Wong, and then Professor Heartland, so we're going to go with that.
I apologize. I'm going to state the obvious, that there's a lot of activity that's now outside the scope of 512C and 512F altogether. And so it is a little bit hard to number crunch based on historical data. And it also is a reminder about the waning scope of both of those laws because of the fact that there are two different ways in which action is taking place that isn't regulated by them. First is what I'll call the fast lane for rights holders, that services may develop systems that allow rights holders to have more trusted interactions with the service. And when they interact with the service using the tools provided by the service, then their actions are not governed by 512C or 512F. The alternative thing that's taking place was, as mentioned, these pre-filtering type removals that never get live to the site. Those aren't taken down by 512C3 notice and not regulated by 512F. And so there's a lot of activity that is outside now the scope of this entire regulatory scheme. So to your answer about could we develop an optimal scheme for 512C or 512F, we have to acknowledge how much activity is taking place outside of the scope of those. And then we can draw our own conclusions whether that's actually a good thing that the DMCA facilitated or a problem because now all this activity no longer is being properly regulated by Congress's scheme.
Okay, Mr. Wong?
Yes, as to see the transparency and the taking down policy, Google always and YouTube always claim how much money they give to content creators, how many links they removed, how many videos they removed, but they never tell us how much money they earned by using content creators' work without permission. I think it's technically doable. If everyone says, oh, this is too complicated, let's go one step by step. How much money you earned each year, each quarter, by using content creators' work without permission, and the links, the videos you removed. Oh, you remove the video, you keep the money. That's the best business I have ever heard. I just take your PC, go out for a while, then I take it back. That doesn't make any sense. My 7-year-old son took a book from the gym, and no one's there. He read it, and he returned back tomorrow morning, first thing. She said, no one noticed that. Then later today, Daddy, did I do the right thing? Even a 7-year-old boy understands this is not the right thing to do. You need to ask permission first. Okay, I think Google should do way, way more than that. Just taking down and keep the money. At least I have the right to know how much money you earned using my stuff without my permission. Did I ask too much? You can keep the money, but just tell me how much money you earned. Is this a fair question?
Okay, thank you. Professor Heartland.
All right, 3 quick points. Lens is wrong. The absence of good faith is not the same thing as bad faith. So it's wrong on the merits, but it's also wrong as a matter of policy, right? And it makes no sense if we have to consider fair use, then why don't we have to consider all of the other possible defenses? And the court doesn't have an answer for that. But even within the Lens framework, I think it's totally possible to use an algorithm to assess whether you can take something down in good faith. And so I believe that with an algorithm, you can tell that something is infringing, but it's much more difficult to tell if something is not infringing, i.e. if it's fair use. So for example, the entire Harry Potter movie is on a website. The algorithm can take that down. That's good faith within Lens. Second point is...
Before you go to your second point,
Sure.
sorry, could I? So just to make sure I'm clear, so are you arguing that Lens is wrong both as a matter of legal interpretation, but also policy?
Correct.
Okay, now on the first point, I mean, could you sort of walk me through why you reached that conclusion? I mean, if the statute says that you can't, that in 512C, there has to be a statement that that there's a good faith belief that the use of material is not authorized by the law.
Yeah, and so
So why is making that affirmation not without having made an inquiry, not a knowing misrepresentation?
Because the absence of good faith isn't the same thing as having actually subjective bad faith, right? So the 512F standard is subjective bad faith. The 512C standard is you have good faith. There's a difference.
The 512F standard is
A knowing
knowing misrepresentation.
Right.
If you know that you have not
Well, it could be,
acquired,
both, but it's not always both, is what I'm saying. And so under the Ninth Circuit's reasoning, they were equated, where there can be overlap. Yeah.
anyone?
It's a distinction a lawyer could love, right? I'm sure many disagree.
Anyone else want to weigh in on Lens? Mr. Graz?
Very briefly, a good heart and an empty head is not good enough for 512.
Okay. Now I'm going to let Dr. Burgess speak to this topic, and then we're going to move away from 512F and to some of the more neglected sections of 512. So, Dr. Burgess.
Well, I just wanted to say the idea that DMCA is working is not supported by any content creators that I know. And by the way, I'm an artist myself. I've signed to 6 major labels in my career. I still see royalty statements, so I have very first-hand knowledge of how this is all working. And to Mr. Pollan's point about gatekeepers, I mean, Google is the new gatekeeper. I know this roundtable is loaded with Google advocates, but Google, for example, YouTube threatens our labels not to promote their content unless they agree to all their content being available on their free service. DMCA was designed to work in a completely different world. UGC did not exist when the DMCA was written. And the idea that it works, it doesn't work for content creators at all. It's not working right now.
Okay, thank you. So moving away from 512F, I want to start talking about two sections of the DMCA that we didn't hear a lot about at the initial roundtables, and we haven't heard much about today. And those are 512I and 512J. And so starting with I, during our time period, there was one case, Strike 3 Holdings versus Doe. The court found a good cause to issue a subpoena because the plaintiff did not request a subpoena from the clerk of the court pursuant to 512H, but instead filed a lawsuit that seeks the John Doe defendant's identity through a Rule 45 subpoena. Does this standard run contrary to Congress's goal with the DMCA to encourage cooperation between the online service providers and the rights holders and to reduce the burden of pursuing remedies in court? Is it correct? Is it wrong? Was the court misapplying how they should be thinking about subpoenas under the DMCA? Who wants to take that? Ms. Gilles.
Well, so there's another provision which we've also somewhat ignored, which is the 512H. And I know that at the last roundtable hearing, I complained about it. Mostly because I don't know if there's actually been a ton of case law that's really percolated up, certainly not to an appellate level, and you tend to see things that are happening more at the beginnings of litigation. So things wash out at that point. But I think it's really important to drive home the fact that what we are talking about with the internet is expression online, and that expression is protected, and that includes the full suite of First Amendment expressive rights, including the right to anonymity. Even outside the copyright context, where you deal with people trying to subpoena the identity of the speaker, there's some significant due process problems that arrive when we start to litigate through that. But there seems to be even graver problems when we start putting it in the copyright context of what the due process protections are. In terms of the Strike 3 Holdings, I did look at that case before I came here, and I kind of threw up my hands in horror because none of it, whether we're leaning towards Rule 45 or whether we're leaning towards 512H, I'm not convinced that there's adequate protections built in for users. And however we consider the subpoena context in copyright cases, especially arising out of the DMCA, we need to make that a point of emphasis to protect that right to anonymous speech and make it meaningful from a due process perspective.
Okay, and just to clarify the record, since I saw some very confused looks over there, it is 512H that we're talking about. I was reading from my outline, and it's numbered I, okay. And so I just sort of flipped them around.
Strike 3 holding cases.
So no, we are talking about 512H. Does that mean anyone else has comments that they would like to? Mr. Graz.
One brief comment with respect to 512H. There have certainly been a large number of 512H subpoenas from Strike 3 Holdings. One thing that in the context not of that particular case where the subpoena was denied, but in the context of a number of other cases where subpoenas have been issued, one thing I think to note about a development in the 512H sphere is that many courts have, because of the potentially embarrassing nature of the copyrighted material at issue in the Strike 3 Holdings cases, have placed protections in place to allow copyright infringement cases to proceed without permitting the public disclosure of the identity of the accused infringer. And I think that's an important development that helps separate out copyright interests from anonymity interests and prevents copyright cases from being brought not for a legitimate purpose of seeking recompense for infringement, but in order to hold up someone's reputation in order to disclose that they like a particular kind of copyrighted content. The other thing I want to mention briefly, and I know she is on the next panel, but Ms. McSherry of the Electronic Frontier Foundation is counsel in a case where a recipient of a 512H subpoena is moving to quash that subpoena on the ground that the very thin copyright interest at issue there, that is posting a portion of a published work in order to criticize the published work itself, doesn't counterbalance the anonymity interest there of someone criticizing a religious group that is seeking the identity of the person who may still be a member of the religious group and face serious social sanction rather than any sort of copyright related concern.
Okay, I think I saw Ms. Wolf, then Professor Goldman.
Okay, 3 quick points. One, kind of unfortunate that too many copyright cases come out of the pornography industry, because sometimes I think it skews some decisions. I think just uploading content should not per se be equivalent to making speech. If you're commenting or criticizing, that's one thing, but I think just uploading other people's content is not the equal, I think, of speech. The other is, I think, the ability to make subpoenas are going to be more and more important, because particularly you can't find identities of hosts and sites to even do takedown notices sometime, or to contact infringers because of the privacy laws coming from Europe, that many identities are now protected, and you wouldn't even be able to determine, even if you're outside 512, who's using content.
Okay. Professor Goldman?
Yeah, thank you, and I appreciate your clarification, because I was one of those puzzled people, because I thought, I know the 512H holding on strike 3. So just a few points. 512H is an artifact of a different time. If we were to draft the statute today, almost certainly we would not draft it the way it's currently drafted. And part of that's because we really don't provide the same kind of court unsupervised access to identity in other types of legal doctrines. This is a very copyright-specific solution. In almost all other circumstances, a person who wants to identify a tortious actor must go and get the court's permission. But 512H says you don't need the judge's permission at all. You automatically get as a matter of right. I don't think that's the deal we would strike today. And so 512H is, I think, just an anachronism more than anything else. I'd say that 512H's fast lane to getting identity has become one of the sources of copyright trolling, that it has enabled people to go and bring lawsuits with this sole intent of extracting settlements, not of litigating. And that's why the particular ruling you mentioned was so noteworthy, because the judge said, I'm not going to do it. I'm not going to allow you to have that kind of unfettered access to identity, knowing that the consequences that you're not going to come back in court, you're going to resolve this extrajudicially without my supervision, without necessary legal merits to do so. I will also point out that privacy law would make 512H look even more of an anachronism. We've seen that in the who is context, that the availability to sue people who might be alleged trademark infringers for domain names is now not going to be automatically given either. And in fact, most domain name registrants now use a privacy protective service anyway to overcome the who is model. Those were the models of the 1990s. The 2010s would have a much more privacy protective approach than 512H.
So speaking of potential anachronisms, I mentioned earlier 512J. That's one section of the statute that sort of nobody talks about. There are very few cases. Is that just DOA now? Is there anything left? Do we care about 512J? Should we care about 512J? Professor Goldman.
I have blogged almost every 512J case I've seen, because I do find them so interesting. Because 512J to me was an integral part of the DMCA structure. The DMCA safe harbor does not say that service providers can avoid liability. The DMCA safe harbor says that they can avoid financial damages and be subject to a limited injunction, which is spelled out in 512J. So for me, the idea is that 512J is available to all of the copyright owners who are upset about infringement online. There's still the possibility of exercising the rights that are permitted under that, and I do not understand why that has not been more widely explored. That does not make sense to me.
Okay, Mrs. Ray, then Mr. Graz.
Thank you, and my comment just goes back to the previous one on 512H. Just wanted to echo their comments and their support. Their notion that with the subpoenas, what we have found a lot is that the subpoenas are used, unfortunately, instead of to protect copyrights, they're used to gain access to personal information that is then used to try to reach a settlement, try to embarrass. And we're just trying to find a way to get support for that, as well as in instances where some of these cases where they're actually asking for the information, it pertains to individuals who aren't even in that particular location, that they are outside the court's jurisdiction. So while the goal of the act was to try to provide another avenue for protecting copyrights and give them another a method of enforcing, a method of resolving it. Most cases we're finding the same as they have, that it's not being used for the intended way.
Mr. Graz?
I have been puzzled about the same thing. That is, why is nobody using 512J? The best answer I've been able to come up with is this. The lack of cases in which 512J is invoked is an indication of how cooperation has happened between online service providers and centers of takedown notices, not in the sense of necessarily holding hands, singing Kumbaya, and trying to do things that are the best possible thing that could be done for the enforcement of copyrights, but instead in that what 512J gets you is you can force the online service provider to do the thing that the online service provider is otherwise provided with pretty good incentives to do, and we want the online service provider to do. That is, to take things down, to terminate subscribers who are involved, who are habitual infringers, and so on. And because those things happen anyway without the need of a 512J injunction, we don't see a lot of 512J injunctions because the purpose of that injunction has already been achieved.
Okay, so we're coming down to our last 15 minutes or so, and I know that we've had a very lively discussion on earlier panels about repeat infringer, so I'm going to give all of you the opportunity to discuss repeat infringer as well. Obviously, we've heard a lot about Cox, Motherless, Grande, how the three of them can be reconciled. Can they be reconciled? Did they get it right? Did they get it wrong? I'd be interested to hear any panelists' thoughts on that.
Getting along well? You mean the providers and the content owners, right?
It's on the repeat infringer policy, so requiring that ISPs take notices in of infringers and then ultimately terminate their accounts.
Oh.
Ms. Tumarella, you haven't spoken today.
Yeah, so I think an earlier panelist described it as a spectrum between Motherless and Cox, and we appreciate that flexibility considering startups often don't have the manpower to kind of deal with this the way a large company does. And I think earlier someone said Motherless was run by one person who was dealing with all of this. So definitely appreciate that flexibility. That being said, I think a necessary condition for startup growth is certainty, and clarity on repeat infringer policy would really help companies to make sure they're operating within the lines, and when they're trying to do the right thing, know that they're doing the right thing and can tell investors that they're doing the right thing so that they don't have to worry about litigation down the road.
So what would that type of certainty look like? Are you talking about changes to the statute? Are you talking about guiding documents that the industry comes up with? I mean, what is...
I think there's a bunch of different avenues that could work here, and I don't want to say one is specifically the right thing. Obviously, anything that could be consensus-based and incorporate the perspective of small companies would be really important in developing something that like an industry guidance document. But we want to make sure that there's flexibility here, and there's a chance for startups to have input, so their perspective is seen.
Okay, Mr. Schwartz.
Well, for CTA and also CCIA, we got into the Cox case as an amicus. It was on the contributory infringement side. Others addressed the 512 side, but generally in getting into that case and looking at what happened, one thing that hasn't been mentioned is the terrific abuse that was part of the notices that Cox received. They out of hand rejected the ones that had license offers attached to them and other things, which I think the courts have generally taken a dim view of. That's not to justify, a lot of the unfortunate stuff that came into the record. And the other thing we observed is that when that unfortunate stuff of, people saying, the heck with it, or we'll reinstate the guy the next day, came into the record, when the judge said 512 has nothing to do with this case, when they got to the contributory infringement trial, it all came in as metrics having to do with 512 compliance, having nothing at all to do with contributory infringement. And you can search the record for anything that really did, but the jury nevertheless was allowed to consider all of it. So in view of the shortness of time, that's really what I can add on it, but I think it's a couple of points that have stuck with me since we got involved in that case, and it wasn't completely cleaned up on the contributory infringement side by the Fourth Circuit.
Okay, Ms. Gilles, then Mr. Graz, then Mrs. Ray, then Mr. Fierst.
Thank you. Well, this is what I was alluding to in my opening comments, and the Cox Court at the Fourth Circuit dealt with this head on, where the Cox's argument was that accruals for purposes of termination policy should not be contingent on anything but adjudicated claims. And this is the problem with the DMCA system, to the extent that an alleged claim can cause such sanction and effect for the platform, for the user, for expression, for a speaker's future expressive rights. And this is a problem. The Cox Court didn't seem to think that this was a big problem, but this is a big problem, because this essentially becomes prior restraint, where you are causing censorship on a non-adjudicated claim, and I think that's not going to pass First Amendment muster. The second point that's related, that is also an undercurrent through all the cases we've been discussing today, is how it's not black and white. Sometimes maybe infringement is black and white, where it's clearly infringing or clearly not, but we're not certain. And I know in the first session we were discussing even whether you could derive certainty if you saw a watermark. One of the differences between the Mavericks case and the case that came afterwards was the second one didn't have watermarks, the first one did, and the court was critical in the second case of, well, why didn't you even put a watermark on it? But you still can't get that certainty. In any sort of, when you're looking at a bit of expression, the things that you need to figure out whether there's infringement is it copyrightable? Who owns it? Is it jointly owned? Who posted it under license? And was it posted as a fair use? And there's other considerations. And the senders are getting this wrong. If the senders are getting it wrong, the platforms won't have any hope of getting it right either. But they're being forced to essentially defer to the complaint and presume it legitimate and take actions accordingly. And those actions are hostile to individual expression, and especially when we start talking about termination policies, to the future expressive rights of users. Just to double back to what I was mentioning with that Twitter anecdote, I've also seen it in the contact with people on YouTube who are worried not just that their video got taken down, but it was a strike accrued. I'm sorry I don't have direct data on this, but I think that there are accruing anecdotes of people stressed out that it's not just that they're losing the individual expression, but that they're losing the ability to make future expression because they're stuck in a system where there's been some injustice where they think their video was fine, and the problem is not just fine, that video is down, whatever, but that it's going to affect their ability to make future videos and contribute future expression to it.
Well,
And
I guess, I mean, when you're reading Cox, you're not really struck necessarily by the expression of these repeat infringers. And we've also heard earlier, don't make the perfect the enemy of the good. I mean, do you have any room for there being a continuum here for the ISPs to employ these policies?
Well, one of the things that I believe Mr. Schwartz was just pointing out is in Cox itself, there were severe problems with significant numbers of the notices that were received. In fact, the court itself, the district court, dismissed all the claims based on, I believe it was the Roundtable publishers, as not being valid expressions of copyright claims. It took an enormous amount of, in the overall record, there had been voluminous notices sent sent to Cox. And the court itself crossed out a considerable volume of those voluminous notices as not being valid expressions of copyright, and then ignored what the impact would be because it acknowledged that there were problems with so many of them, but then still managed to default to the presumption that the ones that remained inherently must have been good, and that the platform needed to have immediately regarded them as being valid, when the platform had significant experience to know that there were validity problems with the copyright notices, not just in terms of the claims, but also in terms of the form. The court criticized them for having blacklisted Rights Corp notices prior to BMG having hired Rights Corp, but it didn't discuss why Rights Corp had been blacklisted. So even if we want to go to the idea that file sharing is a certain type of infringing activity, and on a full service ISP, that's a certain type of thing, and we want to treat it differently, we still have the abuse problem built into it. And then if we try to build a system that ignores that abuse, and then we extrapolate it out to more, I think the point that you were making is like social media tends to be more expressive type of platforms. It's the same system that rules them all. Granted, there we're in a 512C environment, but if we don't have adequate ways of getting rid of the abuse, and yet we still have these incredible sanctions falling on users who are expressors, we'll take out all of it, including the stuff that we think should actually have been an easier decision.
Okay, Mr. Graz.
I want to begin by answering Ms. Smith's question to Ms. Gilles regarding a continuum, and my answer is yes. That is, a continuum is critically necessary in the context of repeat infringer policy, especially as when you distinguish, as we must, between different kinds of service providers, different kinds of subscribers, and different kinds of activity. I think all of those things go into the question of whether the implementation of a repeat infringer policy is reasonable, and indeed ought to go into each individual service provider's individual decision-making on whether to terminate a particular user. And in my experience, the service providers who, in Mr. Fierce's words, care, take all of those things into account and want to get rid of abusers, but don't want to trammel either lawful speech or the non-infringing speech of people who make mistakes. And so I think what I come back to here is the difference between conduit ISPs and edge services in this context. With respect to conduit ISPs, the continuum, one way the continuum was implemented, and maybe one model for voluntary implementation of that continuum, is the copyright alert system that we haven't heard a lot about. That was a way of doing a graduated response where the ultimate sanction, the thing at the end of the road, was a very serious thing. And I think the seriousness of terminating conduit ISP service is of critical importance, and I think it's not that hard to square with the goals of the DMCA. I think the reason, on an earlier panel we heard Packingham mentioned, the reason Packingham is important is not necessarily because the First Amendment imposes limitations on Congress's ability to act in this area, though it may. I think the reason that Packingham is important is because it points out, as a policy matter, these other things that we consider so important as a society, avoiding, spousal abuse and child abuse, yield to the necessity of people using the internet, and people who make mistakes, and maybe even repeated mistakes on those same sites. Those interests, at least in some cases, where it's appropriate, where it's reasonable, also yield to the necessity of participating in society using the internet.
So you mentioned the difference between conduits and other types of service providers. They all have the same knowledge standards, though, but notice and takedown doesn't apply to 512As, although with Cox and Grande, maybe it does apply to 512As, and that they are expected to be at least keeping track of some of the notices they're receiving, even though they don't have a formal system for it. So I guess the question I have, and I'm also hopeful that Mrs. Ray can respond to this in terms of what her members are doing, but is since Cox, and I know Grande is too recent to have affected any sort of practical response, but since Cox, how are conduit types reconciling the fact that maybe there isn't that much of a difference between them and the other types of service providers in terms of obligations?
So I don't have any information for you about what is happening on the ground. All I can add before I defer to Ms. Ray is to say that from the point of view, it still isn't, even after Cox, a notice and takedown type regime. That is, notices that are received are one input to a reasonable determination whether someone is a habitual abusive infringer.
Okay. Since you were called out, I'm going to go to Mrs. Ray, and then Mr. Fierce will let you have the last word.
Thank you. Just quickly, I wanted to second the notion of Ms. Gilles and Mr. Schwartz on their comments about whether there's a need to forward the actual notices and what the obligations, responsibilities are on behalf of the ISP when they forward those actual notices, especially if they contain the settlement language like as in Cox. That left a big question mark for our members after the court decision. Secondly, to Ms. Gilles' point about sort of invalid DMCA notices. In particular, the question that's come up for us is where they're sent to multiple email addresses as opposed to just to the DMCA email address. Can they completely disregard any emails, any notices that come to an email address other than their DMCA one, assuming, of course, they have a valid operational DMCA email address? But more to your question, and thank you for the opportunity. The members that we're seeing, that they are concerned with the Grande opinion, recognizing that it's only summary judgment phase, but it really did put a pretty hefty obligation on the ISPs and does not seem to take into account the concerns that have been raised here about the number of valid email addresses, the number of valid notices. The other concern that comes up is what do we do with public Wi-Fi? That we have had some success through technology with seeing a reduced number of copyright infringement notices or DMCA notices through instances where peer-to-peer networking is no longer used, where the members, the subscribers are using more of a streaming service to get their videos, to get their music. That has helped. But where it hasn't helped is in the public Wi-Fi context, that they have educated their members. A lot of times they find that members have kind of an open Wi-Fi, and when they educate their subscribers as to how to close down their public Wi-Fi so that people can't park on the street and use it, that helps until another one pops up somewhere else. In the case of Wi-Fi in hotels, Wi-Fi in restaurants, they're kind of concerned of what are they going to do about that. So any clarification in that respect would be helpful. And then finally, to the extent there's an expectation, obligation of ISPs to disconnect their subscribers at some point, we need further clarification and perhaps coordination with the state government, with the Federal Communications Commission. State governments have considered internet service as an essential service. Therefore, there's going to be certain very concrete steps that would be needed prior to disconnecting. From the FCC standpoint, there are performance obligations that these ISPs are required to meet to comply with FCC requirements. So they're kind of in a box here, and any further guidance, any absolute clarification would be helpful. Thank you.
Okay, thank you. Mr. Fierce.
Yeah, I wanted to provide a very partial answer to Mr. Greenberg's question before on repeat infringer, which is what examples do we know of strategic behavior of sort of either batching or serially sending infringement notices and then using that to sort of strategically try to get a particular user removed. If you look through our Lumen notices, I would say I do see these. It's infrequent, so I don't want to overstate it. It's a rarity, but they do happen, and it may happen more elsewhere, and it may increase. If you look in the Lumen notices that we upload related to infringement, one of the very idiosyncratic but interesting cases on this is an investigative journalism publication run out of Ecuador that was using Flickr photographs of politicians posted by the government of Ecuador's Flickr account. And the government of Ecuador then sent some copyright takedown, some DMCA takedown notices, along with a request that account be banned based on repeat infringement. So, as I say, that is at the margins of what we're talking about, but I think it really suggests the potential for mischief that can be done with strategic behavior around these repeat infringer policies. From my perspective, the risk and the lack of clarity around the necessity of going to summary judgment to have it evaluated whether the way that we responded to that was appropriate is a six-figure cost that is gigantic for a startup. So we very much want to do the right thing, and it's very clear that that's a form of political speech that we want to be very careful about. But at least as to how repeat infringer policy works in the existing cases, there wasn't really any guidance for me to de-risk that in a way that was meaningful. Thanks.
Okay, thank you. So with that, we've come to the end of the domestic portion of the day. I just want to remind everyone there is going to be an open mic. If you have additional comments or other concerns that you want to raise that we didn't get to, please feel free to sign up so that you can speak during that. We're going to take a 15-minute break, and then we will be back with the international panel at 2:45.